Right now, for some legal analysis, we bring in criminal defense lawyer Julius Kim. Thank you so much for being with us. First, what's your reaction to this verdict?
Good afternoon, Nicole. I don't think anyone was really too surprised by the verdict. As soon as Mr. Brooks decided that he wanted to represent himself, I think that everyone recognized that this is going to be an uphill battle for him, not to mention the fact that it was well known that there was a lot of evidence in this case against him, and that it would be a difficult case to defend, even if his attorneys were still on the case.
Well, so Julius, let's focus in on Brooks' behavior. We heard from him a bit in Sloan's piece there. It was really the main focus of much of this trial. Victims' family members are expected to give statements at his sentencing, which is next week. Do you think we're going to see more of that behavior from Brooks?
I sure hope we don't. And I don't think we will. And the reason why I don't think we will is because Mr. Brooks alluded to the fact that in his closing argument, actually, that a child had mentioned to him that she didn't appreciate the way he was acting at the outset of the trial, quite frankly. Now, that wasn't him. And I think that might have gotten to him, and his behavior seemed to have straightened out a little bit. At least it got better. So I think that I hope that Mr. Brooks is going to be respectful of the sentencing process and is not going to be acting out. But who knows with Mr. Brooks?
Well, and let's talk about some of the charges that he was now found guilty of. You tweeted yesterday saying the jury would not be considering reckless homicide charges. Those actually carry a lesser sentence than the intentional homicide of which he was convicted. Brooks never asked for lesser charges. The judge didn't include them. But does the court or the state have any obligation to make sure that he was aware that he could, in fact, ask for those lesser charges?
That's a great question, Nicole. I don't think that the state has got an obligation to ask for these lesser included charges. They certainly had the option to do that. As to whether the court had an obligation to ask for them, that's debatable, quite honestly. If the evidence could support lesser charges, then I think that the court should have considered at least offering those lesser included charges to the jury. Now, there's no requirement that she do so. We do know that she had the power to offer those to the jury, but that's a decision that ultimately Judge Darrell made for herself. And ultimately, the Court of Appeals is going to look at it and see whether she should have offered the lesser included or not.
Last question for you, Julius. We know the DA expects him to appeal. Do you think it is at this point inevitable that he will, in fact, appeal this conviction?
Oh, yeah, absolutely. In Wisconsin, if someone gets convicted of first-degree intentional homicide, that case is automatically going to be reviewed by a team of attorneys, even by the public defender's office. And just judging from Mr. Brooks' behavior and attitude, certainly this case is going to be looked at for appeal.
All right, Julius, we thank you so much for weighing in. Thank you.
My pleasure.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.